panel on the temporal limits of armed conflict, indefinite NIACs, forever wars, and prolonged occupation. I'm Omar Shahabi, and I'm very happy to be moderating in a minimalist fashion a great panel today. Just introduce them quickly, and I'll say a few more words about them when we come on to each. Here to my... Can't hear a word. Is my mic on?
There, now it is.
My mic is on. Okay, now it is. Yeah. The room is small, so. All right, to my left is Yael Ronen from the Hebrew University, Alka Pradhan, a human rights attorney, Ian Hurd from Northwestern University here, and Lakmini Senervatna, okay, from the International Committee of the Red Cross. And I will skip any sort of elaborate chapeau, except to say that we are trying today to harmonize some very different interventions, all of which are timely, urgent even, and all explore situations that strain existing concepts in the laws of war and straining the paradigms in one way or another. So the interventions today will address such questions as who gets to decide when an armed conflict is in fact over, the permissibility of the laws of self-defense, you might say the excessive permissibility, the use of self-defense and national security discourse in maintaining the forever wars we're exploring today. And we see these questions underlying more detailed questions about, for instance, why the 25-year-old United States authorization on the use of military force remains in effect, the logic animating the claim of a terrorism exception to state immunity, and so forth. All right. I don't know that we agreed on an order. Why don't I come first to Lakmini, if that's okay? Sorry, didn't mean to ambush you. Lakmini, what do you see as the consequences, or perhaps the unintended consequences, that flow from the way that we characterize situations of armed conflict? And more broadly, what is the relationship between the law of war and the law contra bellum, right, the law of peace, if you will? In your view, does international humanitarian law or the law of armed conflict, does it prolong wars? In the sense of allowing the normal order of things to be suspended, perhaps indefinitely, based on the factual reality of effective control of foreign territory, and by maintaining IHL's separation from the underlying lawfulness of the situation giving rise to its application?
Great. Thank you, Omar. Thank you to ASIL for inviting the International Committee of the Red Cross to this panel. IHL, as you know, or the law of armed conflict, as others call it, is near and dear to the ICRC's heart, and in fact, the foundational framework within which we operate. So it's a pleasure to discuss something that is relevant to that framework. I see two parts to your question. So I'll start off on the first part about the classification piece itself. And recall some of the things that I think are important for us to note before we get into the question of what do you expect by classifying a conflict, and what happens if what are the unintended consequences, as you called it. So as you know, IHL recognizes two types of armed conflict, and the ICRC's commentary to the Geneva Conventions, which draws on state practice, jurisprudence, and IHL principles, have laid down criteria to define non-international armed conflicts and international armed conflicts. I won't go through the details of that because that's not the purpose of this discussion. But suffice it to say that the criteria are well established. In our opinion, there's nothing to question there. And of course, the definition of international armed conflict also includes belligerent occupation. And over time, the ICRC has also come up with proposed approaches to define how parties become actors, states or non-state actors become parties to armed conflict by virtue of the support they provide to parties that are already in conflict. And I think Alka will come to that in her intervention. Now, what that means is if the criteria are satisfied, then international law, obligations of international humanitarian law apply. And it casts obligations on the parties and then in turn recognizes that certain protections apply to those who are affected by armed conflict and the victims of armed conflict. And the victims are not only civilians or those who are not taking part in the hostilities, but also those who are no longer taking part in hostilities. So the protections apply to those who have been taking part in hostilities as well. And these obligations go from conduct of hostilities to detention to management of the dead and so on and so forth. And it also allows us, the ICRC, to come into the context and talk to the parties and implement our mandate, as it were. Now, what that means is that once the criteria are satisfied and once you bring in international humanitarian law, you also, in fact, admit that certain core values, core underlying principles are also in operation. One being that you don't, for the application of international humanitarian law, the legality of the conflict shouldn't matter. So ad bellum and in bello differentiation. So the cause of the conflict should not determine the fact that international humanitarian law applies. And because the reason for the difference being that humanitarian law is primarily and fundamentally humanitarian in nature. It doesn't go into the cause or the justness of the conflict. And then there's the principle of equality of belligerence, right? You recognize the fact that parties to armed conflict are equal. Of course, there are certain differences when it comes to IAC and NIAC in terms of conferring POW status, for example, but fundamentally you recognize there's equality of belligerence. And you recognize that there is a responsibility and obligation on the parties to respect and ensure respect for international humanitarian law. And you also recognize and accept that there is non-reciprocity in the obligations, which is that the fact that your opponent is not respecting obligations cast upon it doesn't give you a card to do the same. So your obligations apply. So what that means is if these criteria are there, are fulfilled, IHL applies, which means if they're not there, they don't apply, right? But I think what's important to recognize is that the fact that when the criteria are fulfilled, the fact that you decide to give that situation a different name doesn't take away the obligation. So the fact that you're calling it hybrid warfare, the fact that you're calling it competition, proxy warfare, that doesn't take away the application of IHL. So the criteria are clear. If they are fulfilled, then international humanitarian law apply. And then the other important thing to note is that the investment that states have to make to prepare for conflict in order to make sure that you comply with international humanitarian law. Now, you can come to the question whether that is encouragement to armed conflict, which I hope to get to in a moment. But the important thing is that the law requires, particularly if you look at the law of international armed conflict, there are preparatory measures that you have to take in peacetime in preparation to comply with the law during war. So the intended consequence, to answer your question, Omar, is that you recognize that there are limits in war, right? Even in the worst times of human conduct, there are limits. But then are there unintended consequences? That's, I think, the most sensitive question to ask ourselves. So then, on the one hand, the unintended consequence, one could say, is, does that prolong war, the application of IHL? Does that encourage war? And does that give reason for parties to continue the war? So I think there are a few things we have to remind ourselves in this. One is the ICRC's experience, which is over 160 years in working during and in the aftermath of armed conflict. There are no short and sharp wars. There are consequences that are dire consequences and unacceptable consequences of armed conflict that prevail during conflict and in the aftermath of conflict. So that's one thing to recall, no short and sharp wars. Then if you look at the criticism of that IHL prolongs war, encourages resort to war, fuels war economies, and so on and so forth, the ICRC doesn't have, or is not aware of any empirical evidence that says applying IHL prolongs war, nor that applying IHL shortens war, right? And it also doesn't have any evidence to show that it preserves, it's an incentive to go to war. That's like saying, the application of IHL in outer space, to military operations in outer space, militarizes it. That's not the question. In my opinion, in the ICRC's opinion, this is the wrong question to ask, because what you're underlying in that is should we discard this body of law, or should we apply it in a different way? Right? And then we have to ask ourselves, what is the alternative if we don't apply these principles? What are you, in fact, saying? Because what you're saying then is that the justness of the cause, whether you are the aggressor or the victim, entitles you to interpret the law differently, or have less accountability, or the principles are interpreted in certain ways that the aggressor gets to do, the victim gets to apply it in a different way from the aggressor. And what does that mean? We all know the cost of that kind of interpretation. In economic terms, in humanitarian terms, in financial terms, in political terms, doesn't that also prolong war if you go down that path? And then I think it's important to sort of deconstruct this notion and look at the object and purpose of international humanitarian law. Because the object and purpose of humanitarian law is to strike the balance between military necessity and humanity. It is not supposed to prevent war. It is not supposed to resolve situations of armed conflict. It's not supposed to displace the UN Charter. In fact, if you look at the Diplomatic Conference of 1949, it clearly says that the object is not to get into questions of legality of war and to question the application of the UN Charter. So I'll conclude by giving two or three more points about what the ICRC believes in terms of IHL's contribution to peace. And here I emphasize on the fact that it's about contributing to finding pathways towards peace, and not peace building, as it were. Because on the one hand, as our chief legal officer recently wrote in our International Review of the Red Cross, humanitarian restraint in war and quest for peace are not mutually exclusive, but complementary. Because if you look at the obligations in international humanitarian law, and you sort of look at the different obligations and the protections that are afforded under IHL, there are clear examples of where IHL foster conditions to promote peace. How you treat detainees, when do you release them, what do you do with regard to missing persons, what do you do with regard to how do you conduct the war, and how it reduces the cost of reconstruction. So you're essentially fostering conditions for promoting peace. And you're encouraging belligerents to create humanitarian spaces to protect victims of war. If you often neglected point in Common Article 3 is the possibility for parties to come to special agreements to comply with the convention. That is not something that you pay a lot of attention to in Common Article 3. And it supports peace building in providing a framework for transitional justice, because you in fact recognize that impunity is not what is encouraged. The provisions in Additional Protocol 2 about pardons, about recognizing that belligerent immunity, for example. So I think the bottom line is to recognize the fact that you have to let IHL do its thing, which is not to prevent war or to resolve conflict, and then look to other ways in which to do that, and not question the fact that international humanitarian law is not doing its job. Back to you, Omar.
Great. Thank you very much, Lakmini. I'll go next to Yael. So in the International Court of Justice's advisory opinion of 19 July 2024, the court characterizes Israel's occupation of the territory it seized in 1967 as prolonged and the abuses of that occupation sustained. And yet, by my reading, and you may disagree, the court doesn't fully grapple with those characterizations in the language of the law of state responsibility. It does in other aspects. Of course, the dispositif has cessation and restitution, and so there's grappling with state responsibility there, but not so much in these concepts of sustained occupation and prolonged occupation and sustained abuse. So how do you understand these concepts, and what does the court's treatment of these concepts tell us?
Okay, thank you, Omar, and I want to thank the organizers, and I'd like to begin by acknowledging the privilege that I have to be sitting here while my country continues to be at war. It is now day 560 of the longest and deadliest war in the Israeli-Palestinian conflict, with the lives of 2 million people increasingly at risk and under threat, with no moral or legal justification at this stage. And while this is not connected directly to legally not connected directly to the topic of this panel, I think in practice, the issue that and the issue of prolonged occupation are not entirely unrelated. So to speak about the notion of prolonged occupation and abuse of the power of the occupant, I want to start by recapping on what the court said. So the court started dealing with the issue of prolongation by noting that the prolongation of occupation does not in itself render the occupation unlawful. What matters is whether the occupation is temporary or not. And there's this presumption that occupation is of short duration. But then there's the question of what happens when the occupation is no longer short. The question is whether it's no longer temporary. And I think it depends on what is the reason for the failure of the occupation to be of short duration. It may be that the basis for the military action that brought the occupation about persists, primarily that if self-defense concerns persist. And this would normally affect the manner in which the occupation is administered. And the temporary character of the occupation may remain credible. Another option is that what motivates the prolongation of the occupation are external factors, external motivation. For example, expansionism, in which case the claim that the occupation is still temporary becomes non-credible. And I think it's worth pointing in this context that Israel has for a long time argued that the occupation is temporary but indefinite. Whatever that is supposed to mean. Now, the thing is that both factors may apply, or both factors of both types, both legitimate and illegitimate, may apply simultaneously, and this is something that the court hasn't addressed directly. So the court took the view, at least implicitly, that in the occupied Palestinian territories, it's external motives that are at play. Now, when it spoke of sustained abuse, what it spoke of was Israel abusing its position as an occupant, and this sustained abuse or misuse of power resulted in de jure or de facto annexation, depending if we're speaking about East Jerusalem or the rest of the West Bank, and in the violation of the right to self-determination. And this is what rendered Israel's presence in the territory as occupant illegal. And I think it's the use of the term abuse or sustained abuse rather than violations of IHL is actually important, because had the court remained with Israel is violating IHL, it would have remained, the advisory opinion would have remained in the context of is the law of occupation complied with or not. And what the court did was actually go a step further and says the abuse of power that the occupant, Israel is an occupant, it has power in the factual sense rather than the legal sense. And it abuses that power in order to further annexation and the violation of the right to self-determination. And this allowed it to go outside the law of occupation and on that basis declare that Israel's presence in the territory was unlawful, or I think in shorthand we can say that the occupation is illegal. And I think it actually, there's another novelty in the advisory opinion, and this is where the prolongation of the occupation connects with the right to self-determination. Now, any occupation is by definition an infringement on the right to self-determination. And this was pointed out by Judge, it was now President Iwasawa when he pointed this fact out. The question is, when do we say that the right to self-determination is not only infringed upon, but also violated? And there is no clear answer to that in international law. But what the court says was that the fact that this infringement has been going on for decades, that's the prolongation of the infringement on the right to self-determination, and the fact that it seems that there's no end in sight. The prolongation in retrospect and prospectively, that is what renders the infringement a violation of the right to self-determination, and that being a violation of a peremptory norms leads to the illegality of the occupation. So I think the court has gone for, this is an interesting opinion in many ways. One of them is this idea that how do we recognize that self-determination is violated and not only infringed upon? That is through the prolongation. Now, with regard to your question about the court declining to apply, basically to exhaust what state responsibility allows, I'm not sure that I agree. So the court held that Israel should withdraw from the territory as rapidly as possible. It held that Israel should cease the establishment of settlements and dismantle the existing one and remove the settlers. That it should provide reparations to all victims of the occupation, and the states should not recognize the situation arising from the illegal situation arising from the illegal situation, and not assist in maintaining it. And it does raise a few questions. So for example, why does the court speak of withdrawing from the territory as rapidly as possible? So if the occupation is legal, presumably Israel needs to withdraw immediately, and there's no justification for waiting. But I think one reason for this might be precisely the fact that the court avoided dealing or engaging fully with the question of what do you do in addition to external motivations for the occupation, there may also be legitimate grounds for the occupation. But basically, Israel's argument is a half-hearted argument, in part because Israel didn't actually participate in the proceedings, but also because its submission on the matter was quite vague. But the argument is, well, the occupation is required for self-defense purposes. So some judges had their reservations precisely on that ground, that the court disregarded this issue. And for this reason, they didn't join in part of the dispositif. Other judges, that would have been judges Tomka, Abram, and Oresco. Judges Cleveland and Nolte, I think, they answered this question by saying, well, there is no longer a credible self-defense argument or self-defense claim when in practice there is annexation. And this is an interesting proposition, that the illegitimate motivations or that the legitimate grounds are subordinated to the illegitimate ones. And perhaps what the court ultimately did was adopt wording that leaves some room to take account of security considerations, and that is why it said as rapidly as possible rather than immediately and unconditionally, in order to leave the space without actually saying we leave the space, and it also allowed the dissenting or partly dissenting judges to join in most of the decision. I think another issue that has been raised is that the advisory opinion might have gone further in what it demands of third states, either a prohibition on obstructing action to realize the right to self-determination, non-forcible action to realize the right to self-determination, or even going beyond that, and that would be to obligate states to actively act towards the realization of the right to self-determination, to the Palestinian right to self-determination. But I think to expect that from the court, or to expect that from the notion of state responsibility, would have been going a little too far, because state responsibility is concerned with the consequences of a violation of international law by a state, and not going beyond that. Leaving alone the question of what is being requested from the court in the advisory opinion, and the expectation that it would go beyond what did this mean for the occupation, rather than to expect the court to go beyond what this means for the occupation, but rather to say what this means for Palestinian statehood or for Palestinian action in other ways. I think that would have been asking too much of the court. But I'm not sure. I'm not sure state responsibility allows for more than that. And I think the right to self-determination, what does that imply in terms of the obligations of their states, is also a matter that is. The court may have been able to go further than that, but I would not say that it was required to go further than that. Thank you.
Okay, I'll go in order next to Alka. So, Alka, you have a unique, to say the least, perspective on forever wars and their effects as counsel in the Guantanamo Bay military commissions, right? Proceedings that have stumbled along for 20 plus years, and most recently, for those of us who aren't following the granular details, resulting in a plea bargain in the highest profile of the cases that was rejected by the former U.S. Secretary of Defense. So what do you see, or what insights can you draw from the Guantanamo experience amongst your other many experiences? How does the authorization of these military force and the establishment, but not conclusion of the military commissions, what insights do you draw from that on the larger question of forever wars?
Thank you, Omar, and thank you to the organizers and to ASIL for having us. And I'm very intimidated sitting on this panel with such excellent experts. So the first thing I have to say is that nothing, for reasons that will become very apparent, nothing I say represents the opinion of the Department of Defense. I hear the laughs. You're right to laugh when you hear what I have to say. And nothing I say should be taken to confirm or deny anything that the U.S. government considers to be classified. So my perspective, as you mentioned, Omar, is as a litigator, and I heard Lakmini, you say, talk about the concept of equal co-belligerence. And so as a litigator at Guantanamo and at the International Criminal Court, to some extent, my job is really the pursuit of justice and equal protections for men who have been accused of terrorism and war crimes, but also may have been mistreated, may have been arbitrarily detained, and have in all cases been tortured by state parties. And so they are, my clients' cases are predicated on forever wars. And the two most, looking specifically at the 9/11 case, which has been going on at Guantanamo in its second incarnation for just crossed the 13-year mark in pretrial hearings. There's never been a trial. The two most striking things are, first, the manipulation of the law of war to limit rights only for one party, the non-state party, and that's, as an aside, we actually argue that my client in particular has never been a member of al-Qaeda, but that's another argument for another day. And to hold them essentially forever and prosecute them before a military commission. And then the second is that the excuse of war and security is used to really brutally torture them, as has been recognized time and time and time again in various courts and by, I think, everyone in the world at this point. As sort of a baseline refresher, right, Lakmini did an excellent job of this, but pre 9/11, our understanding was generally that terrorists were tried under criminal law, right? They not under IHL. And the U.S. position since 9/11 has sort of gone in a different direction. The United States government's position is that al-Qaeda unilaterally declared war on the United States, which is traditionally a state function, and that the war began in 1996, but members of al-Qaeda or associated forces don't really have any rights of combatancy. Their rights are relegated to a sort of statement that's repeated often by the Department of Defense that Common Article 3 applies, right? And anyone who's been to Guantanamo, read anything about Guantanamo knows that even now, 23 years later, the honest reality doesn't really reflect Common Article 3 on the ground. The premise of the forever war, in our case, is the authorization for the use of military force, which has morphed over time to include all manner of associated forces all over the world. And so what I kind of want to do is take a step back and look at the characteristics of prolonged NIACs and why we don't necessarily want unnecessarily prolonged non-international armed conflicts. Taking just the example of the US wars around the world on terror, the absence of a controlling test for determining the end of a non-international armed conflict has resulted in, right, not least, the prolonged exposure of civilians to the harms of armed conflict, right? You see civilians being readily sort of accepted as collateral damage, which is of course permissible in armed conflict, but outside of armed conflict, they would be entitled to due process, entitled perhaps to reparations, and they're sort of dismissed. And you saw that early on in Afghanistan, you saw that in Iraq, you saw that with the drone wars. And so we now have, right, victims all over the world who are just swept under the rug of civilian collateral damage under this pretense, I'll say, of forever war. We also know from experience that the framing of a NIAC may tempt, right, realistically, states to resist ending that framework in order to enjoy the comparatively liberal use of force regime that allows detention and targeting. Lakmini made the comment, the application of IHL's, the application of IHL, there's no real evidence that the application of IHL gives parties a reason to continue war. And I don't mean to misquote you, Lakmini, so please tell me if I am. And look, I don't think there are empirical studies on this, but I do think that that the United States, if we're looking just at the United States, has taken every opportunity to shoehorn groups and individuals and causes under the so-called war on terror, into a so-called war framework. And the answer, I would posit, is not to discard, right? Not to discard IHL, but to apply it when it is appropriate and to make sure that we have limitations on when it is appropriate so that we maintain the specialis nature of the lex. On the flip side, right, NIAC designations may benefit non-state organized groups, right? And we saw this a little bit. So for example, in the Al-Hassan case, which is my case at the International Criminal Court, NIAC designation may benefit non-state armed groups when they are, when they're battling a sort of weaker state apparatus and are trying to weaken them further through prolonged armed violence that would otherwise be prohibited, otherwise be, categorized as acts of terror and dealt with under ordinary criminal law. So again, the absence of a controlling test for the legal termination really is a huge hole. And so there have been a number of proposed tests over time, but the vagueness of those tests, in my opinion, is reflected in the lack of wide adoption, and it doesn't give us a lot to work with in court. And as more international criminal law cases are NIAC-based, I think we should be thinking about how the law is going to hold up in a courtroom. We certainly can't rely on the deterrent effect of the law alone, and especially not for powerful states or traditional big powers. So in this regard, actually my colleague, Ben Farley, who's right there and should be targeted for any specific questions you have, wrote a paper, it was mentioned yesterday in the Assembly, proposing a new test that we think would address some of the issues that we're seeing in these cases arising out of the forever wars. And we believe that this is a more practical test. Now, so it has three parts. The first is that is sort of a reverse Tadich, right? That either the intensity of the violence or the organization of the party diminishes below the threshold necessary to constitute a NIAC. Not a full cessation of all violence, because again, under Tadich, right, there may be isolated or sporadic acts of violence that do not rise to the level of a non-international armed conflict, but the diminution of one of those factors, so essentially a reverse Tadich. Second of all, you want a fact-based analysis, obviously, in every case. And so the second is that fact-based analysis of when observable circumstances suggest that an armed conflict has terminated, and what we call in the paper, what we call the quality of pacification. And for that, you look to the statements of the parties, the fulfillment of objectives, and the implementation of concrete steps like disarmament, for example, towards peace. And then the third part, which is novel, and I think most likely to engender some pushback, I'd love to hear some, is the timer, that all of these circumstances have to be in place for a period of at least 5 months. The 5-month timer that we placed on this comes from the International Criminal Court's trial chamber decision in the Bemba case, where the trial chamber found that a period of 5 months was to be considered protracted in order to be able to find the existence of a non-international armed conflict. So that was sort of a minimum period of time. And so in the interest of symmetry, right, we argue that all of those factors that we just discussed have to be satisfied together for at least a minimum of 5 months. And this is still a high standard, given that we're layering the factual analysis, but it provides a concrete time limitation that is so sorely lacking right now, because it is too easy for the United States or any other major power, France in the case of the International Criminal Court, or any other powerful state, right, to argue that a NIAC continues in order to justify heavy-handed measures, prolonged detention, mistreatment of detainees, et cetera. So ultimately, we're really normalizing the lex specialis in a very destructive way and at the expense of criminal law and human rights law. So I'll stop there.
Thank you, Alka, for the very official position of the Department of Defense and the wider United States government.
I'm going to be doged any minute.
Ian, I'm going to ask you to do what a more competent moderator might do, which is draw a line through these data points of the prior interventions and opine on whether you see the laws of war losing their normative pool in constraining state power, or, as you put it, speak to the entanglement of state power and legal authority and how that is leading to a creative refashioning of these rules in a new and dangerous direction.
Wow. Well, thanks. It's nice to be here. I guess what I hear across the panel are two kind of distinct questions. One is, what does international law say about armed conflict in various ways? And the second is, what is it that the law of armed conflict then says about the world that we live in, about human affairs or about international affairs? So let me think about each of those in turn. On the first, what international law says about armed conflict, about making it legal, it's really striking that the international law literature talks a lot about the criteria for the start of lawful war, but not much about the closure of lawful war. The criteria for beginning a war that's lawful are easily recited. I imagine every student of international law can speak about Article 2.4 and 51 of the Charter, and and speak too about a lot of the controversies that are kind of well worked out regarding what counts and imminence and preemptive self-defense and how you know, and all the stuff about self-defense that makes law lawful is really well known. But seeing the world that way kind of opens a window that never gets closed, because there isn't really, aside from the things that have been mentioned up here, much literature that we can offer our students about the closure of lawful conflict. And that's interesting. It's a bit as if the rules of baseball were written such that you knew how to play the game, but it neglected to mention that at 9 innings, you're done. So how do you live like in a world like that? Well, I think in practice, thinking about armed conflict, what seems kind of obvious is that we think of armed conflict, international armed conflict is my main area, as ending when the states decide that it ends. Right? When a government decides that it's not worth continuing or its security anxieties have been allayed, then the conflict ends. And as Alka was suggesting, there's a heavy reliance here on kind of empirical behavioral observation of circumstances to decide when the conflict ends. And the decision is made by the state, based on its own sense of security, presumably, if we're taking that framework. So the end of military activity comes when the state decides to stop, which isn't really a legal category, unless we want to write one onto it after the fact, and kind of in the way that Alka and colleagues have been suggesting. It's not really a legal decision. It's, I don't know, a political decision maybe. I think maybe it's an emotional decision. It's a decision that your sense of security is no longer under threat, and therefore the self doesn't need defending anymore, and therefore the circumstances have changed, therefore you're not in a condition of lawful self-defense anymore. So that's kind of funny, that the opening of war is so legalized and the closing of international conflict is not. It's, again, a little bit like a paragraph that has a parenthesis in it where you've opened your parens and you've never closed it. The language of the two is kind of different, the legal as opposed to the political or the emotional, between the beginning and the end of war. But actually, I'm going to suggest that the two do match by reflecting back on the start of war and seeing that the laws of war that define lawful self-defense are pretty much based on the same kind of emotional, psychological condition as we think about at the end. By this I mean that Article 2.4 and 51 together have come to mean not what they say in the text, but that it's lawful to go to war, to use force internationally, when the self is threatened, or the self or its interests are threatened. And those are psychological, emotional determinations that are made by the self. And we can cite, I'm sure, many examples in which we see a kind of opportunistic creative interpretation of the self in order to assert the legality of the use of force in some other place, right, where your citizens are in jeopardy or you sense that your interests are at stake. So the legality of the start of war has turned over the years into this sort of calculation regarding the interests of the self around the world. And that to me looks a lot like the psychological determination in the close of war as well. So the two may actually match, but they don't really match on legal terms. They match in this psychological, emotional, political dimension. So on the second question then, what does all this say about the world that we live in? Let me suggest 3 quick things in closing. The first is that this requires that we think about the legality of war as a political resource rather than an objective legal category. The legality of war is useful to governments. It's an instrument that they can use to advance their interests. That doesn't negate the power of law. In fact, it enhances it or it reflects it. It shows how useful the law is, but useful in political resource form. Second, it suggests how much of the meaning of law, at least around self-defense, is determined by the practices of strong states as they reinterpret and reassert interpretations. The textbooks come to write the language of self-defense law around concepts like anticipation and imminence and interests and threat, rather than the black letter law in the Charter. And finally, and the biggest, is that then what we see in international law for law of armed conflict is that it empowers governments. It legitimizes the use of force rather than constraining or restraining it. And this, I think, gets into conversation with a nice note that recently came out from Monica Hakimi and Jacob Katz-Kogan in the Journal regarding the ways that law and power are entangled around the use of force. Thanks.
Thank you, Ian. That's all I have by way of canned questions. So I want to ask a question myself, taking moderator's prerogative here. I see a dialogue between what Lakmini said and what Alka said. Lakmini mentioned the equality of belligerents, and Alka mentioned the manipulation in the characterization of the war itself, or the non-international armed conflict, and almost increasing the status of one's enemy to the level of an armed group with the requisite level of coordination. And what both make me think of is the situation in Western Sahara with the Frente Polisario. And it's non-state actors or non-recognized states have been making unilateral undertakings to abide by the laws of war for a long time, but the Polisario, not so long ago, took advantage of Article 96, Paragraph 3 of the first additional protocol, allowing for the deposit of a unilateral declaration of adherence to the conventions, because Morocco is a high contracting party. And it comes at an important time for the Polisario because it's recognition, or the recognition of the Sahrawi Arab Democratic Republic, its government, has been waning. And the African continent has been rescinding its recognition of the SADR. And so the Polisario is in need of something to validate its equality, if not as an African state, then as a legitimate non-state actor. And so my question for both of you, in no particular order, and not limiting either of you, is what to make of that phenomenon in what it contributes to a forever war, right? Is the uplift that the Polisario gets from its Article 96.3 declaration, and recognizing that's fairly esoteric amongst international law nerds, does that contribute to the prolongation of a war, or is it a feature or a flaw of the laws of armed conflict? Yeah, it's an incoherent question, but do your best.
Okay. I think, for me, the question goes back to what's the object and purpose of international humanitarian law? Why are these provisions in the Geneva Conventions and the additional protocols, right? Is it supposed to, that provision, is that with a view to conferring a status that you don't otherwise get by virtue of another body of law? Or is it meant to achieve a different purpose? So I fundamentally feel that we're asking the wrong questions from international humanitarian law when we ask, does that prolong a war, or does that confer a status that you don't otherwise get? So for me, that's also I also see a parallel between that question and counterterrorism frameworks existing alongside international humanitarian law. You know, does one outplace the other? Because in the ICRC's view, you can have those two bodies of law coexisting, recognizing that the two bodies of law serve a different purpose. As long as you have carve-outs for international humanitarian law, you can still have counterterrorism frameworks. So in the same way, I think and I fundamentally and fully agree with what Ian said. As the ICRC, we agree that compliance with the body of law that is international humanitarian law is first and foremost a political will. Whether you want to do it, whether you want to apply it, whether you want to recognize that it applies in the first place is a political decision. And then the rest follows. So I don't think, I think those are two different things to ask ourselves and not necessarily conflate legality of conferring status versus protections, recognizing the protections that are, and sort of the object and purpose of IHL. Omar, I don't know whether I answered your question.
No, you did from a perspective. I would fundamentally disagree only insofar as you ask what the purpose of the additional protocols are. As I read, and I've read the notes of the 3-year diplomatic conference, it was very much to give non-state actors who were denied legitimacy in Article 44.3, in 96.3. In my view, the fact that you can augment, if you're a non-state actor, your unilateral undertaking of compliance to a deposited unilateral declaration is meaningful, and its purpose there is to give status to those previously denied status. But that's more of a teleological question. I appreciate your perspective. Sorry, that's ultra vires, the moderator. Go.
No, I think, listen, just briefly, right? I think the phenomenon of a non-state actor saying that they intend to be bound by IHL is something to be welcomed, right? But at the same time, IHL is non-reciprocal. So, it doesn't absolve state parties of being bound whether or not, regardless of what a non-state actor says. And as a pathway to legitimacy, I would say, I would go back to a fact-based inquiry in terms of determining whether or not, just because a party says they intend to be bound by IHL doesn't mean that IHL necessarily applies in that moment. And so IHL, I would rest on the fact that IHL should not artificially displace, right, the normal domestic criminal law or human rights law without the rest of the circumstances being in place that create a NIAC.
Okay, great. We're getting down to the lightning round. Again, I failed as a moderator to keep people on time. Tuyel, and again, this is my own hobby horse, if you will. I've heard a lot of talk this past few days about the law of state responsibility, but always focused on the articles on state responsibility. And I gnash my teeth when I hear that, because the articles of state responsibility are a codification of the lex lata that existed 25 years ago. And we're concerned about concepts of the laws of war being tortured so as to give a legal veneer to these perpetual states of exception. What's not to say that the law of state responsibility isn't similarly being abused? When you mentioned in your remarks the sort of paucity of the law and the need for the court to stay within the law. Well, what to the objection that law, in fact, was old in 1999 or 2001 and is really old and outmoded now?
Whether it's outmoded and whether it's or changed or not would be a question of international consensus. There's nothing to say that it cannot change, but just to say, but it is not enough to say that it ought to change, or that it may have changed. And I think it's interesting. Yesterday, there was a session in which the question was what to do about interstate hostage taking, and Finola Neolan said what is required is multilateral action. And I think it's becoming truer and truer that the assumption that international law would be enforced through legal unilateral action is proving unsuccessful. And there's need for multilateral action, but there needs to be a political will. And ultimately, and I think this is, and like when he said it earlier about the application of IHL, yeah, you said that, I think. The application of IHL requires political will. Ultimately, this is what we're dealing with all the time. The law will not stop war. It's political will that will do that. Law only provides the tools, and it's the same here. If there's political will for multilateral action, then the law will provide. Yep.
Yeah, fair enough.
There.
Ian, I have no question for you. Just an imperative. Pontificate, preach on what you've heard. That's unfair,
Well,
I'm sorry, but
I'll
go
answer
ahead.
the question that I thought you were going to ask, which is like, why are you trying to bring us down so much?
Why are you trying to bring us down so much?
Yeah, I'm not trying to bring you down, but I'm answering it. I'm a political science person, and I'm answering my own discipline's quirk, which I think is that so many people in political science who study international law take a kind of enchanted view of the law as the kind of solution to political problems. And that requires a kind of unrealistic image of what international law can do, and it requires a kind of a wishful thinking about what it's actually doing. So to me, it seems like the first step in understanding how to make things better is probably to understand how they're working now, and that requires seeing the political forces that are running through the application of international law to various goals. And that's what I hear crossing across all the presentations so far. With 2 minutes left so far. I mean, maybe there's something coming.
To Oka, yeah. Would you like a question, or do you... I can give you a question if you want one.
I'll
Okay.
take the opportunity to bring us all down for a minute. Always. No,
Again, U.S. government position.
yeah, the official U.S. government. I'm just kidding. For all of you, like, government people in the House. No, I mean, I want to bring it back to, like, what we're doing right now, right? I think we talk about the forever wars, and we see what's happening in the news, and a lot of us are tearing our hair out because everyone, it seems like the media, and it seems like a lot of lawyers are saying, my goodness, like, how are these things possible? How is it possible that we are right now, right? If you go on Blue Sky or you go on Twitter, right now, the Bluebonnet ICE Detention Center, there's video coming out of there with men being forced to sign declarations that they are part of Tren de Aragua, right, in English, which may not be their first language, and presumably to be rendered to CICOT, right? So, and there's a lot of surprise about how is this possible? And the answer is, this is not rogue, this is not, far removed. This is the White House currently building on the exact tools of executive power that have been provided to them post 9/11 that Bush, Obama, and Biden all built on over time. So we've ended up with exactly what many of us predicted 10 or 15 years ago with U.S. violations of IHL. And we've normalized, for example, Guantanamo to such an extent that we forget how illegal it actually is, that the current targeting of, Tren de Aragua or any of these groups, new groups of migrant detainees at Guantanamo, use of the Alien Enemies Act, these are legally only a very short step away from what has taken place at Guantanamo or with the drone targeting or in Iraq for 23 years. And if I seem angry, it's because I am. It is because a lot of us have sat in rooms with the victims of U.S. wars, with their families, have seen the effects firsthand, and on the communities abroad, and the anger and pain and resentment that our crimes engender that ultimately make us all less safe. So I will end with that.
Okay, so the stop load is going from... Is that to her intervention? I would agree. The stoplight has gone to red, but I do want to ask Ian a legitimate question in the time allowed. It's telling me to please wrap.
With a smiley face.
Sure.
There's a W on the wrap, though, so we're safe.
Oh, right, okay. You don't want to hear me rap. If I understand you correctly, or maybe I don't, and correct me if I'm wrong, I see you saying that our emotions are taking us to stay in this permanent state of exception. And my fear is the permanent state of exception takes us to a place where we conclude, non licet, there is no law. So you were descriptive and not prescriptive, but if you were to offer a prescription for how to deal with this problem, do you see it the same way, that allowing emotion and leaving the end of a war to be an emotional stroke political decision currently unconstrained by law, what is the remedy?
Well, I don't think it's unconstrained by law. I think that it's constituted by law, because the law is the language in which these decisions are explained and legitimized. What to do instead? I don't know that there is any alternative to explaining ourselves through the concepts and rules and laws that we find around us. That may just be the human condition. There's lots of things that are unfortunate, but they exist. I've been to a Kenny G concert.
Unfortunate indeed.
Well, that's not fair. No, I take that back. Can we roll back the tape on that? I've been to spring break on the Florida coast. But I think understanding the way that power is using law and other institutions is a crucial step to understanding the world that we live in, and if one is so inclined then to thinking about ways in which it might be changed.
That's excellent. Thank you. Well, we laugh or we cry, but join me in thanking our panelists for a good discussion.